Hi everyone, I'm Shreya. I'm a community lead and a member of the Untitled community. I will be moderating today's session on EB-1's regression with Seth Leech. There's so much to be said about Seth, but I'll try to keep it short and sweet. Seth Leech is a partner with Whiteman Osterman Hanna and head of the firm's immigration practice. He has exceptional expertise in the immigration needs of engineers, scientists, researchers, and university personnel. He works with entrepreneurs, investors, and new businesses under immigration classifications of L1A, E1, E2, and O1. He is one of the small number of attorneys in the US who has successfully presented petitions under the new International Entrepreneur Program. A humanitarian, he has worked a number of pro bono cases, most recently with a nonprofit organization to protect Afghans who supported the US mission in Afghanistan. Being a long-standing member of the American Immigration Lawyers Association since 1996, he has presented immigration-related topics before local colleges and several community organizations. Today, he has been kind enough to give his valuable time to the Unshackled community. Seth will answer the questions you asked through the chat box, and we will do our best to answer all of your questions. Sounds good?
That sounds great.
Yeah.
And Shreya, you forgot to mention that I needed a lot of caffeine for this session right here. I would like to answer everybody's questions as they come in. However, I do want to give some context to this issue. I want to speak for a few minutes, and I will try to keep it short so that we can give everybody the time that they need to ask questions. And so what I'm going to say to you will be kind of three segments. What is the background to the issue? What are the problems? And what are some things that you can and should consider? And so this problem begins, and I promise I'm not going to bore you with history, but this problem begins with World War II. Why would World War II have any impact on what's going on today? Well, after World War II, there was a huge influx of Europeans into the United States. And by the late 50s and early 60s, we said to ourselves as a country, we need to kind of cut back on European immigration and allow other countries to be able to immigrate to the US from at that time, what they called the developing world. So this was the origin of the per country limitations that are the problem that we are facing, or one of the problems that we're facing today, which is that no one country can take up more than 7% of the visas in any category. So not only are there global limitations, there are approximately 40,000 visas or green cards available in EB-1, and then in EB-2, and then in EB-3. But then there are these per country limitations, which say that only 7% of those visas in each category can be allocated to individuals from any particular country. And to make matters worse, this includes family members as well. So if you have one Indian immigrant and her husband, she has her husband, and then she has 3 kids, then it's not just the primaries who are taking up these numbers, but it's the whole family. So that's five green cards that are being taken up right there. So that's 5 of that very limited number of visas in each category. So this is kind of the structure of the system. The problem that we're all facing, and I have to say this is very, very unique in my career. I've been doing this almost 30 years. And although there were some people who predicted this even years ago. We have not seen EB-1 for Indians be current since December of 2022. And by midsummer, there was a retrogression of almost 10 years to 2012. And then I looked at a lot of the commentators, very, very, very bright commentators, the Murphy law firm, Charles Cuck, others. And I thought as well, okay, by the beginning of the fiscal year, October 2023, we're going to start to see some of this backlog disappear for EB-1 and maybe disappear even completely. But that didn't happen. And there was a bounce ahead for filing of about 6 years, which a lot of people are like, oh, great, maybe in another month or two, things will be current again. The problem, however, is now starting to emerge that there is about how many people are actually in the line. And there is no exact science to this. All of us, especially a lot of people online with us today, have engineering, mathematics backgrounds, and we'd like to be able to just look and say, this is the number of EB-1s that are pending right now, and this is exactly how long the line is. But we don't know. We don't know. And the US government has even used the word opaque to describe how it is to determine how many people are in line right now. But I remember when I came to the Unshackled event in July, somebody said to me, well, it's going to be 200 years before we as Indians will be able in the EB-2 or EB-3 to be able to even become current. And, I laughed at that. I said, that's very funny. But sadly, that may be true. There may be this massive, massive line, which is created by the global limitations and the per country limitations. And the fact that, and I'm looking at this right now, there is an estimate that there are 462,000 Indian nationals with approved EB cases in all categories. And there are 970,000 Indians that are in line and waiting for eligibility. So the first number were people with approved EB cases who are waiting for their green cards, who are in line with maybe approved I-140s. And the 970,000 is the total number of Indians who are waiting. The rest of the world, and I see that there are people who are not necessarily Indian on this, is in a much better place right now. And just to give you an example, as of December 2022, there were 381,000 Indians with EB-2 cases waiting for numbers to become current. I'm sorry, there were 381,000 total people waiting, but 351,000 of them were Indian. So the rest of the world is in a much better place because only 30,000 of that were allocated to other people from other places in the world, where the vast majority were Indians waiting for this, for their numbers to become current. So there is a great article, and I would encourage you to read it. I usually don't, we surf the internet and we find, 50 different law firms that describe what the problem is. And, that's great. Every lawyer wants to describe what the problem is. But there is a really famous immigration lawyer. His name is Charles Cuck, and that's K-U-C-K. And he wrote an article back in August called The Coming of the Visa Apocalypse. And the article is chock full of data. And, again, many of you are scientists. You want to be able to calculate and see things. His article is chock full of data. Why is his article different? Well, he was the former president of the American Immigration Lawyers Association. He's got probably close to 40 years of experience, and he's involved with many of the advocacy efforts. So his article, The Coming of the Visa Apocalypse, which you'll find on his website, is probably one of the better articles that you can find online, which describes the magnitude of this problem. We don't know how many perms are in process, how many prevailing wages are in process. The Department of Labor is not really great, so we don't know how these numbers are going to be added to. Some cases are set for consular processing, and the Department of State doesn't necessarily adequately report those numbers. So these numbers are, as the US government said, truly opaque. We don't know really what the final numbers are. And on the positive side, we don't know how many people have dropped out of the processes either. So I have some suggestions, and I'm going to make those now, and then we can answer questions. And some of these suggestions are not great. I mean, they are what they are right now. If you have not done something to secure a priority date and getting an I-140, submitted and potentially approved, you need to work to do whatever you can, because the numbers indicate that there are hundreds of thousands of people that are out there trying to secure a priority date. Do whatever you can, whether that's working with your employer to get your perm done and then premium processing a response on the I-140. Well, your priority date is already secured by the labor certification, so why would I recommend premium processing a response? We are living in very difficult times in terms of certain industries and a lot of layoffs. And if you're just going to wait 6, 10, 18 months for your I-140 and you get laid off, then you don't have that priority date. You haven't secured the priority date until really the I-140 has been approved. So do whatever you can to secure a priority date, because there are hundreds of thousands of people who are also trying to secure a priority date. So get a priority date secured so you can be a little bit earlier in the line, and premium process that I-140 if you can. I mean, there are certain petitions where the individual cannot pay for premium processing, or maybe shouldn't pay for premium processing. This is not one of them. You can tell your company, hey, I'll pay for premium processing. If you're not going to do it, I will pay for premium processing. There's nothing that prevents you from paying for premium processing. Work on an EB-1 profile. I did a previous AMA, and I know that there have been many, many other AMAs which have talked about how to develop an EB-1 profile. And in fact, I'm seeing a lot of the dialogue and correspondence on the Unshackled forum about building EB-1 profiles. Build an EB-1 profile and try to get an EB-1 submitted at some point. Maybe that will advance you in the line. Be creative. I had an individual I spoke to the other day who's an Unshackled member, and she does not yet qualify for an EB-1 and will not for some time. And her company is just at the beginning of the prevailing wage process. So she's probably like 2.5 years away or more from securing a priority date. And she said, what about the national interest waiver? What about a self-petition? So she doesn't qualify for EB-1A. She's 2.5 years away from getting a priority date from an employer-sponsored perm application, but she qualifies for a national interest waiver. And so I'm like, okay, let's get that submitted as soon as possible, because then you can secure a priority date through that. Some interesting facts. If you are Indian and you're married to someone from another country, you can use that other country for what is called cross-chargeability. So I have a lot of Indian clients who are married to someone from Canada or married to someone from another country. This is something to think about, because then you can use Canada as the country. If you're an Indian married to someone from Canada, you're both here on your H-1B and H-4, you can use Canada as your country of cross-chargeability, meaning that you don't have to be in the Indian line. So just something to kind of keep in the back of your mind. Seek family-based options. Why not? If you've got a brother or a sister in the US, sibling, or anybody else who can petition for you in the family-based category, or a US citizen parent, just do it. Just get yourself in that line as well. Be in multiple lines if you can. We never know what legislation is going to, how legislation is going to change things, or how you might end up being faster in one category or another. We all saw that a few years ago when people were trying to downgrade their EB-2s to EB-3s. Right now, on the downgrade issue, I don't see any benefit to that, just because all the lines are backed up, except maybe EB-1, which we don't have good data on the numbers of backlogged EB-1s. I recommend that everybody subscribe to the Visa Bulletin. You can do that by going onto the US Department of State website, so that you can track the numbers and you can read what the US Department of State is saying, perhaps on a monthly basis. Seek other options as well. And clearly you should be getting immigration counsel from your attorneys, from attorneys who are qualified to practice immigration law, who can give you more background on possible other options. I hate to say it, but sometimes people can't go back to their home country because there's a political issue. Okay, you never know. Maybe there's an asylum available. Maybe somebody is considering the date that they want to get married to their U.S. citizen husband. Well, maybe this is the time to kind of fix that date, and because that's also, if you're married to a U.S. citizen, that you're not subject to these priority date backlogs, because if you're married to a U.S. citizen, then that you are considered to be an immediate relative. So I've tried to speak really fast to kind of get everything out there. I did have one question that came in before this even started. One Indian client asked, if I do consular processing, do I avoid these backlogs? No, you don't. It doesn't matter whether you do consular processing or set yourself up for adjustment of status. So doing it an EB-2 or an EB-3 or an EB-1 and requesting that Mumbai or Chennai be notified for consular processing of your immigrant visa green card, it does not take you out of the priority date backlog. That was a question I had received before today. So maybe Shreya, you can tell me what the questions are, and I'll try to answer those as quickly and as efficiently as I can.
Thank you, Seth, for this elaborate introduction of what EB-1 retrogression is, and giving us the talk points of how to combat the delay in the visa. For how long do people have to wait for? I've heard it's 6 years.
Well, unfortunately, if you look at the numbers, especially in the EB-2 and EB-3 categories, I would say from start to current, being current is going to be a very long time. And I hate to repeat these things that I heard before, but I do believe that it's going to be probably greater than 15 years, and perhaps as apocalyptic as Mr. Cuck anticipated in his article. The other thing that I have to say is that there have been legislative efforts over the years. Hey, let's remove the per country limitations. And I've read that this has pitted Indians against other nationalities, because other nationalities are saying, hey, I don't want these per country limitations removed, because then I'm going to be in a backlog that I'm not in now. Mm-hmm. It's really an awful, awful situation, because, this has been something that's been bounced around in legislation for years. And whatever you can do to push your legislators, your U.S. representatives or your congressmen, or to write about this issue, you should do that. But it is very hard to predict how long it will be. I am still somewhat hopeful, although maybe this is being overly optimistic, that EB-1 could become current again. But again, I couldn't find good numbers about how many EB-1 cases have been approved or are in that backlog. If somebody has that information, I would like to know that, where you got it. But again, maybe EB-1 could be current again in a few months, but we'll have to keep an eye on that.
Okay. So I'll give you the first question. It's from Raj, who's asking the estimation on how Q will progress for EB-1, which I think you just answered. And will Congress take any action to fix this? For now, even a Nobel Prize winner entering the queue cannot get a green card, is what he's
That's
saying.
correct. Yeah.
Yes.
And if you look at the numbers, again, maybe 400, I think it was 460,000 that with approved EB cases from India. And if you think about, there's 120,000 more or less available on a yearly basis, plus spillover from other categories that are not used. And only 7% of those cases can get green cards on an annual basis. And family members who are not really considered those kind picking up this visas, then this translates into maybe 8,000 to 10,000 Indians who can get green cards a year based on employment-based categories. But then you add the family members in as also taking these visas. So it is, and I'm very sorry to say, because I'm a very optimistic person and I like to be optimistic. It could be a very, very long time if there is no legislative fix to this. There have been proposed legislative fixes, and in theory, many congress people from both sides of the aisle are on board with this. But then Congress is so gridlocked about other issues that things never happen. Mm-hmm. But some of the proposals have been, okay, at least don't make it so that derivative family members are taking visas as well. That would provide a little bit of relief, but it would not be a tremendous amount of relief, but it would provide a little bit of relief. And that's been proposed before. That's ended up in certain bills, but those bills never make it out of the House or out of the Senate to the other, and then obviously before the president. But the other thing is the global limitations were set many years ago. I mean, I'm 53 years old, and these global limitations were set when I was just a kid. So, we're talking about global limitations that do not reflect the realities of immigration, the professional immigration to the U.S. So that would be we've seen proposals to remove global limitations on EB-1, for example, or to basically increase global limitations across the board in the different categories. But again, because of the gridlock that we see in Congress, we never see kind of any results that come from these proposals.
Okay, thank you.
Okay, yeah, go ahead, Shreya.
So Harsh has another question where he's asking, can I try to get a date on a non-immigrant intent visa, F1? My company lawyers advise that any future F1s might face much higher scrutiny since it's not immigrant intent. They said I should wait till a dual intent like H1B, O1, or L1.
So this is a complicated issue, but I'll be very quick about it. I do file NIWs and EB-1s for people who are on F1 visas or single intent visas. But the individual needs to be completely knowledgeable that doing so could cause a problem with the individual traveling and coming back to the U.S. or getting a new visa. One possible fix is to indicate consular processing on the NIW or EA, Extraordinary Ability Alien I-140, because if you indicate consular processing, then you're indicating an intent to leave the U.S. to get your final green card when the time comes, and so that would reduce perhaps the officer's view that there is immigrant intent, but not eliminate it, because they're going to see that one day you want to immigrate, and so this is something that strategically you need to kind of hammer out with your attorney.
Okay, thank you for clearing that. Pat is asking if the 5-year EAD and AP hinting that it may take 5 years for dates to move forward?
I'm very happy about the 5-year EAD. And I think that the reason that this 5-year EAD came out, it's not just in the employment-based categories. It's in other categories as well. It's for people applying for asylum. It's for people applying even in immediate relative categories in the family-based applications. I think this was a smart idea by USCIS, because it reduces their workload. I think really this is something that they did for themselves to reduce their workload, but it is also a tremendous benefit. And I'm not sure it was inspired by this particular backlog issue though.
Okay, all right. Narendra is saying that he has a family friend who are permanent residents, and can he ask them to sponsor his green card?
Friend? Well, it's not a family-based case because it's a friend, and certainly if your family friend has a company and it's a legitimate, that company needs someone with your services, then certainly.
And what about like a maternal uncle and when it's family based? Can they sponsor
No.
a position?
No. The individuals that can the family members that can sponsor, and again, it would have to be analyzed in your particular situation. The family members that can sponsor are U.S. citizen siblings, not permanent resident siblings, but U.S. citizen siblings, U.S. citizen parents, and in very limited circumstances, lawful permanent resident parents, and U.S. citizen children, and lawful permanent resident spouses, or U.S. citizen spouses. Some of those also have a priority date backlog.
Thank you for answering that. So we have the next question from Darshan, who's asking if a non-research software engineer with master's degree on a H-1B apply for EB-2 NIW and EB-1 NIW.
Well, there is no such thing as an EB-1 NIW. There's only EB-2 NIW. For NIWs, I have definitely worked with people who are in non-research positions who, again, if you meet the NIW criterion, which is demonstrating that you are there's a 3-prong test to determine whether you meet the national interest waiver requirements, and this is all laid out in a case called Matter of Danasar. First is whether you are working in an area of intrinsic merit. So you're working in an area that benefits the U.S. Second, whether you are advancing this area. And third, whether it is justified to waive the normal labor certification requirements. This is a detailed analysis, but certainly I have people who are working with in engineers in big projects, maybe not doing your typical research, who have successfully pursued national interest waivers.
All right, thank you. Sid has a question. He's asking if there is any subpolarization between the various EB-1 categories, EB-1A, EB-1C. Does one more faster than another or get processed with a higher priority? So like which has higher priority and which has faster processing times?
EB-1A, extraordinary ability. EB-1B, outstanding researcher. EB-1C, multinational manager. They're all in the same line.
Jilam is asking if the EB-1 retrogression for India has been seen before historically. If yes, how long did it take to become current? So,
I've been doing this for a long time, and there was EB-1 retrogression, and I don't remember exactly when it was, but I'm going to say probably about 15 years ago. And And that may have been just because of US government inefficiencies, not necessarily because of an actual backlog. But I don't think there has been any other time in history where we have seen this much actual backlog of actually approved cases. Again, there is some hope that EB-1 could become current again in a few months, but there's definitely no guarantee there because we don't have a good sense of what the actual numbers are.
Okay. Manoj is asking if can the dates progress for EB-1A during this fiscal year? That what we see in the October and November visa bulletin. Also, when will, okay, I think let's stop before we go to the next question.
So USCIS, again, and I guess this is one of the problems is that we don't have all of the data. USCIS has said, and there was a recent American Immigration Lawyers Association conversation with the U.S. government where USCIS says that they have sufficient numbers already to use up all the EB-2 and EB-3 numbers for at least this fiscal year in approved cases. But they don't make a comment on the EB-1 specifically. So again, if someone out there has found a good source to get those EB-1 numbers, and I don't see that on any of the attorneys' websites, Charles Cuck doesn't comment specifically on those numbers. I just think that they haven't been released, and that's part of the problem. But it does seem like there's probably not going to be significant advancement in EB-2 or EB-3 based on USCIS's own statement that they have enough approved petitions already for this fiscal year. I hope I'm wrong. I hope they're wrong.
Fingers crossed. Any high-level predictions on where EB-1 final action priority dates are in 6 months or 1 year?
So as we've seen, there was a bounce ahead with the new fiscal year, and again, very highly respected attorney, the Murthy office has predicted or did predict several months ago that things would become current again at some point in this fiscal year. I think that's looking less likely. I'm sorry to say that, but I'm hoping that there will at least be in a few months, maybe filing dates, which would at least get you into the adjustment of status line. Again, we just don't have those numbers on the EB-1 to really make a good prediction.
Okay. Pat's asking, why have the numbers about the individuals in line not being shared for the sake of transparency? Because you would only expect.
You know, that's a question I ask myself as well. You know, if you whatever you read online, whatever you read from that the U.S. government provides, whatever you read in what Mr. Cuck was able to mine out in his Visa Apocalypse article, it only tells, you know, a part of the story, and the rest is hidden. And I think a lot of people have described it that way. And it could be. Maybe this is not some nefarious conspiracy, but I do believe that the government doesn't know themselves. I wrote an article, a law review article, an academic article on this very issue. This was about 15 years ago because we saw the tip of the iceberg at that point in time. And in my article, I described that the government itself does not really have a good sense of how many cases there are out there. And that's because they're with different agencies. Something may be with a consulate. Somebody may have dropped out. Some of them are in the perm phase. And it's just bad accounting on behalf, by the government. So I think the government is being careful so that they don't look really bad when the true number comes out. I don't know. I don't think this is, conspiratorial. I think it's just that they don't know.
All right. That's interesting. Subramaniam's asking, he's saying that he's a PhD candidate on F1, and if he proceeds with NIW with F1 on status, and let's say my NIW petition gets approved, how does it affect my work authorization if I want to move from F1 to H1B in future to maintain work status?
So, you, unfortunately, and I know where this is going, you still have to get through the H1B lottery. Having an approved NIW while you are on an F1, a lot of people like to look at that rule. It's like, oh, you can extend beyond the 6 years indefinitely if you have an approved I-140. That is the case, but that's if you're extending an H-1B beyond the 6 years. So getting an approved I-140 before you've ever had an H-1B doesn't give you that same ability. You're still going to have to get through the H-1B lottery or work for an exempt organization, such as a university or federal research institution or affiliated exempt organization.
Anshuman saying that you said there's 462,000 approved EB-1 Indian applications. Where is this number from? Or no, when is this number from? Also, what is the worst case number for approved EB-1 applications if we had to estimate? Is it that 20% of the total number, 10%? A guess would be helpful.
So the number is 462,000 Indian nationals with approved EB cases. It's not EB-1. It's just in general. And these are estimates that were provided in the Visa Apocalypse article, which again is well researched and based in reality. So that 462,000 is not EB-1 cases. It is all Indian EB cases that are out there. And accordingly, there would be 970,000 Indian immigrants that are waiting for some sort of visa availability. So, which I believe would include that 462,000. So there's close to 1 million Indians that are in these processes at some stage, whether they have an approved I-140 or whether they are still possibly at the prevailing wage stage or something like that.
Divya has a question. She is saying, why did the EB-1 dates move to 2012, which is not very far away from EB-2? Is there any benefit for going to EB-1 category, as we are actually not saving much time by doing so? I feel like 2012 is not the right year. Is it?
Yeah, and the reason that they and this happened at the end of the last fiscal year, that things were rewound or retrogressed to 2012. When the government feels that they are going to oversubscribe a category, like what that means is that they're going to issue. The government doesn't want to be in a position where they've given away more green cards than actually exist. And when the government has that fear, and this is just one motivation, there are numerous other factors involved here, they rewind things or they retrogress things for a huge amount of time, so they can be sure that they've covered absolutely everybody that's in the pipeline and that they're not over-giving of EB-1 or whatever the category is. And I believe that was kind of an extreme retrogression and rewind. And this is why you saw things bounce ahead. And I wrote down some of the numbers here, but this is why you saw things bounce ahead a lot during the new fiscal year. It bounced ahead by 6 years when the new fiscal year started in October. And also we're still in October, but for the November visa bulletin as well. So I think it was their safety mechanism to ensure that they weren't over giving EB-1 visas.
Okay. Sid's asking if people in the employment-based categories even eligible for your EADs, for 5-year EADs and APs? If so, what is the criteria or eligibility?
So if you don't have an I-485 submitted, then you as a primary will not have an ability to get an EAD based on your I-140. But if you have a spouse and you're on H-1B and the spouse gets H-4, then the spouse can get H-4 EAD. My assumption, and I don't know this 100%, is that those, the H-4 EAD spouse will then only get that EAD for the period of the primary's H-1B at that time. And then that can be renewable in 3-year increments as the primary applicant renews their H-1B.
Okay. Murali sent a link with the pending and approved EB-1A applications from the USCIS website. And he's asking, when can we expect the dates to become current for India?
Same question again. I'm being hopeful, but maybe you might at least see a filing, the filing date become current. I'm not sure whether the final action date. You're probably aware that there's those 2 things listed on the visa bulletin. Hoping that filing date for adjustment of status will become current in a few months. But I know this is hard to hear from someone who's supposed to be the expert, but I really have no idea because we don't have the data to really make that kind of prediction. But a lot of people are thinking that in a few months you might have currency on both filing date, perhaps, and maybe even final action date. Hard to say.
Yeah. It's 10:45, and I'll give you the last question if you want to take.
Sounds good. We'll do one more question, and everybody else's we'll put it in an email. I'll respond, and we can post that.
Okay. So Madhu is saying that I had an EB-2 initially and then switched to EB-3 based on my employer's lawyer advice. I don't have a PhD, but do have a master's degree with 8 years of work experience. What is the preparation needed to be able to qualify for EB-1? Are there subcategories of EB-1 I can apply for?
So, great topic. I'll do another AMA on this. I think others have done that in the past. I recommend go to the U.S. government's website, USCIS website, Chapter 2 of the USCIS Policy Manual. It is a great document, and it gives you a very, very clear description of exactly what the USCIS is looking for in each of the criteria for EB-1. So a lot of my clients go here, they cut and paste this into another document. They have the government criteria, and then they fill in boxes on one side about what they can satisfy in these criteria. And a lot of my clients make this their project. Is okay, we have publications, and now what I'm going to do is I'm going to work on getting some publications and fill in this box. But again, USCIS Policy Manual, Chapter 2 on Extraordinary Ability provides tremendously good and detailed information about the criteria for EB-1A.
All right, Seth, thank you so much for answering these questions. You are so informative, and this has been so helpful. I am going to collect all these questions from the chat and add it on the Unshackled event page of today, and you can answer the questions there.
That sounds great. This is a very hard topic, and I appreciate the questions and the opportunity. Thank you.
Yeah, you've done it wonderfully. Thank you again.
All right. Have a great day, everybody.